Good afternoon, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Tuesday, January 20th, 2026 at 2:10 in the afternoon. And so we're here with our legislative counsel, Rick Sago, to do a walkthrough of H639, which is a bill dealing with genetic data privacy. Unfortunately, Representative Shy couldn't make it today, but we will have her come in tomorrow to give us more information about why she proposes this bill. So good afternoon, Rick.
Good afternoon, Rick Sagal, Office of Legislative Counsel. I'm going to share H639 on my screen. So this is, as the chair said, a bill that would provide some genetic data privacy to Vermont consumers. Several states have passed some form of this, either through their comprehensive data privacy or as a separate data privacy law. You don't have to have, this bill is written in a way that you don't have to have a comprehensive data privacy law. It can stand alone. And some states, again, have done that. So the bill starts on page 2, and I'm putting a new chapter, a data privacy chapter, assuming there'll be maybe at some point other bills that would fall under data privacy. So subchapter 1, genetic information privacy. So this would be known as the Genetic Information Privacy Act, that's subsection A. Then we have a lot of definitions. So like a lot of my bills, the definitions are extensive and they're wordy, but they are that way because they are usually very, very important when it comes to the language in the bill. I'll highlight a couple that I think are really, really, really important, even though they're all important. So we have affirmative authorization. That's an intentional act decision by the consumer. Biological sample means any material part of the human discharged therefrom or derivative thereof, such as tissue, blood, urine, or saliva, known to contain. Okay, I practiced this earlier, now it's fading from me. Deoxyribonucleic acid. I think that's close. I'm not going to say it again.
Nicely done.
Because it's DNA. We all know DNA, but deoxyribonucleic acid. That's it. Okay. Consumer is a individual who resides in Vermont. Dark pattern is a user interface designed or manipulated with the substantial effect of subverting or impairing user autonomy, basically tricking the consumer. You've seen that definition before. Direct-to-consumer genetic testing company. This is an important definition because this is the type of entity that is being regulated in this bill. It is an entity that sells, markets, interprets, or otherwise offers consumer-initiated genetic testing products or services directly to consumers. Page 3, analyzes genetic data obtained from a consumer, except to the extent that the analysis is performed by a person licensed in the healing arts for diagnosis or treatment of a medical condition. So when I saw the phrase healing arts, I wasn't quite sure what that meant, and I felt stupid because it really is just a doctor, a dentist. I was thinking more creative arts. I don't know why I thought that, but I did. So in case you were also then not wanting to admit that anyone thought that, I am free to admit that. It is a person licensed in Vermont that's offering some type of actual doctor, dentist type of service.
You say with us, Rick.
Thank you. And this isn't being recorded, is it? Okay. And then we have in the healing arts for diagnosis or treatment of a medical condition. So in other words, if you go to your doctor to have some tests done and you have that sample tested by the doctor's office, the hospital, they would not be covered, right, as a direct-to-consumer genetic testing company, right? Or C, so again, this is what a genetic testing company would be, collects, uses, maintains, or discloses genetic data that is, 1, collected or derived from a direct-to-consumer genetic testing product or service, or directly provided by a consumer. Disclose, disclosing, or disclosure means to solicit, sell, assign, transfer, give, provide, or trade, whether or not for valuable consideration. So express consent's important. That's kind of what this bill is based on. You'll see here that the consumer has to consent to a lot of things. So express consent means a consumer's affirmative authorization to grant permission in response to a clear, meaningful, and prominent notice regarding the collection, use, maintenance, or disclosure of genetic data for a specific purpose. Express consent cannot be inferred from inaction. Agreement obtained through the use of dark patterns does not constitute express consent. Okay, also important, what is genetic data? It's any data, regardless of its format, that results from the analysis of a biological sample, which again can be tissue, urine, saliva, etc., or from another element enabling equivalent information to be obtained and concerns genetic material. Genetic material includes DNA, ribonucleic acid, RNA, genes, chromosomes, don't know how to pronounce that word, alleles, okay. Genomes, alterations, or modifications to DNA or RNA, single nucleotide polymorphisms, and you might want a medical professional to explain to you what those are. Uninterpreted data that results from the analysis of the biological sample, and any information extrapolated, derived, or inferred therefrom. Genetic data does not include de-identified data, and that means data that cannot be used to infer information about or otherwise be linked to a particular individual, provided the business that possesses the information takes reasonable measures to ensure that the information cannot be associated with a consumer or a household, publicly commits to maintain and use the information only in de-identified form and not to attempt to re-identify the information, except the business may periodically attempt to re-identify the information solely for the purpose of determining whether the process satisfies the requirements of the subdivision on the express condition that the business does not disclose or use any information re-identified in this process and destroys the re-identified information upon completion of that periodic assessment, and contractually obligates any recipients of the information to take reasonable measures to ensure that the information cannot be associated with a consumer or household, and to commit to maintaining and using the information only in de-identified form and not to re-identify the information. Genetic data also does not include data or a biological sample to the extent that data or a biological sample is collected, used, and maintained or disclosed. And here you have several research uses, federal research uses. So you have 45 CFR Part 46, the testing of human subjects, or in compliance with all applicable federal and state laws and regulations for the protection of human subjects in research, including the Common Rule, US FDA Parts 50 and 56, and FERPA. Again, this is just government research, and these are typical exceptions you see in these data privacy laws. Genetic testing means any laboratory test of a biological sample from a consumer for the purpose of determining information concerning genetic material contained within the biological sample, or any information extrapolated, derived, or inferred therefrom. A person is just about anything: individual, partnership, corporation, association, etc. Page 6, publicly available information is information that is made available through federal, state, or local records or to the general public from widely distributed media. Public information does not include biometric data collected by a business about a consumer without the consumer's knowledge. Typically, we define biometric data. We don't have it defined here, but it's becoming one of those very similar definitions when it's used. It's your biological identifications, your fingerprints, iris, face scan. I don't know if you have to define it, but it's something we can think about if you think it needs to be defined. Information that is collated and combined to create a consumer profile that is made available to a user of a publicly available website, either in exchange for a payment or free of charge. Information that is made available for sale. An inference that is generated from the information described in 2 or 3 of the subdivision. Obscene visual depictions as defined in federal law. Personal data that is created through the combination of personal data with publicly available information. Genetic data, unless otherwise made publicly available by the consumer to whom the information pertains. Information provided by a consumer on a website or online service made available to all members of the public for free or for a fee, where the consumer has maintained a reasonable expectation of privacy in the information, such as by restricting the information to a specific audience, or intimate images, authentic or computer generated, known to be non-consensual. Okay, top of page 7, service provider. It means a sole, pretty much anything besides an individual, sole proprietorship, partnership, limited liability company, corporation, or other legal entity that is involved in the collection, transportation, and I'm actually wondering if this should be or analysis. I have it in my notes. Something we can ask when this is about here. So is a service provider all three of those things, or are they just one, right? One of the three. So I have that in my notes. So collection, transportation, and analysis of the consumer's biological sample or extracted genetic material on behalf of A, I have that in my notes too. Currently it says the, it should be A, on behalf of a direct-to-consumer genetic testing company, on behalf of any other company that collects, uses, maintains, or discloses genetic data collected or derived from a direct-to-consumer genetic testing product or service, or that is directly provided by a consumer. Okay. Questions about the definitions?
Just have a general question. It feels like we have been reviewing these kinds of definitions over and over and over again in this committee.
Yeah.
Are any of them in law today? And does this align with that? The ones
So-
that are in law?
Sorry, yeah, so the publicly available, right, the publicly available information, I believe, comes from our age-appropriate design code. I need to double check. Todd Delos is here nodding at me. It's been a month or two since I drafted this. I think I matched it with that. I can double check. This is a relatively new definition, and if we don't have it in the age-appropriate design code, it's probably not anywhere else in our statutes. So that one would be one that matches up. But in this bill, consumer is pretty consistent. It's someone that lives in Vermont. We didn't have to define person here, but we did. Genetic testing, as far as I'm concerned, in Title IX, haven't defined genetic testing that I'm aware of, genetic data. So to answer your question, this bill is probably a bit different in that you want to be more careful to define these terms, but there may be a couple that we can double check or if you want to cross-reference it. And so the reason, it's coming back to me, the reason I didn't cross-reference the age-appropriate definition is because that's not effective yet. It's effective Jan 1, 2027. So we don't want to pass a law cross-referencing the law that's not effective yet. So, yeah.
Thank you.
Yeah. Okay, so the requirements on the line 12 of page 7. So privacy terms and consent. To safeguard the privacy, confidentiality, security, and integrity of a consumer's genetic data, a direct-to-consumer genetic testing company shall provide clear and complete information regarding the company's policies and procedures for maintaining, collecting genetic data by making available to a consumer all the following: a summary of its privacy practices written in plain language that includes information about the company's collection, use, maintenance, and disclosure of genetic data, a prominent and easily accessible privacy notice that includes complete information about their data collection, consent, use, access, disclosure, maintenance, etc., and deletion practices, and a notice that the consumer's de-identified genetic or phenotypic information may be shared. I know what that word means. I don't know how to pronounce it. So that's phenotypic. Thank you. That's information that is observed from genetic information. So it's what your age is, what your eye color is, right? may be shared with or disclosed to third parties for research purposes in accordance with 45 CFR Part 46. Okay, so they shall obtain a consumer's express consent for the collection, use, and disclosure of the consumer's genetic data. So this is a pretty big requirement, right? It's one thing to require privacy notice. It's another thing to require express consent. And remember what that definition means. That, you know, what express consent means in this context. For each of the following, the use of the genetic data collected through genetic testing, product, or service offered to the consumer, including who has access to the data, how it may be shared, and the specific purposes for which the data will be collected, used, and disclosed. Express consent for the storage of a consumer's biological sample after the initial testing requested by the consumer has been fulfilled. Consent for each use of genetic data or the biological sample beyond the primary purpose of the testing or service, and inherent contextual uses. Consent for each transfer or disclosure of the consumer's genetic data or sample to a third party other than a service provider, including the name of the third party to which the consumer's genetic data or biological sample will be transferred or disclosed, and the intended purpose of said transfer, except a company shall not require a consumer to expressly consent to the actions in the subdivision in order to receive the services ordered from the company by the consumer. And finally, that they shall consent to the marketing or facilitation of marketing to a consumer based on the consumer's genetic data, or the marketing or facilitation of marketing by a third party based upon the consumer having ordered, purchased, received, or used a genetic testing product or service. Questions about the requirements as far as the express consent of the consumer? So they can do all these things, right? They can store a consumer's genetic data or sample, but you have to get, after you provide the service, but you have to get the express consent of the consumer to do that.
This may be a tip of the iceberg question, but the express notice provision that's in this bill,
Mhm.
I frankly can't remember how we dealt with, or how the amendment that was published to S-71 last spring, that we didn't take testimony. How that compares? Is there an express consent provision in there? Or it's maybe unfair because you haven't had
I
time.
haven't thought about that amendment in a while.
And so I can wait
To the genetic issue or in
Yeah,
general?
I'm trying to wrap my head around and trying to remember how our previous, what we've seen previously compares with this.
I can't say for sure. So
Okay.
let me get back to you on that.
Yeah,
If
no problem.
it's sensitive data, which I think it is, in that version of the data privacy bill, there's certain things you just can't do with sensitive data. So I think this is kind of going in a different direction as far as
It's going away.
in a different direction, right? Because you're saying they can obviously process it because they're companies, you know, that's what they do. But I think it's a different context than the data privacy bill. But I'll double check and make sure, compare the two for you.
Okay.
Yep.
Thank you.
That's okay. So Rick, I'm just thinking back, it might have been before you were with us. At one point, the committee had the UVM cancer study that had brought forth legislation where that was intended to that basically that life insurance policies, that they could not access the genetic data. They couldn't request it or require it in order to write a policy. And so does this affect that how that process works?
So there's language coming up where you wouldn't be able to send that information to a company that makes health insurance decisions, life insurance decisions. There's also federal laws on that, but there is specific in this law protection against that data going to a company that can make a health insurance decision.
So so could that insurance company require in order to provide you, I suppose, if you said, no, I'm not going to give you this information, then they wouldn't give you a policy, is that?
Who's the you? Is it a consumer or is it a company? That's
If the life insurance company wanted to require anyone that wants to get a policy to disclose that and information that they gathered from, for example, the UVM breast cancer study that people participated in.
required disclosure of that. I don't think this bill would prevent a life insurance company from requesting that information. I don't know if there are other laws that would regulate that, but this bill would not prevent that requirement that the life insurance company asks that you disclose a test, right? Is that what you're kind of getting at? Is have you done this type of testing, right?
I mean, because the concern at the time was that the UVM study was not getting enough applicants because people didn't want to have their data produced and then go want to get a life insurance policy and be rejected because they had some markers that made them higher risk. And the insurance company's argument was that, well, if you already know that you're a high risk because you've had this study done, then you come to us and want to take out a maximum life insurance policy then they're forced to make decisions based on incomplete.
Well, without having all the information. I think this is a little different because you're not getting your genome, you're getting your DNA to find out where your ancestry is.
This is more 23andMe.
Yeah. This is, so I don't.
But the pheno.
Yes.
Because that would definitely qualify, which would anti-selection, which would not be good for insurance companies. Sorry. No, okay. So getting back to what Kirk was saying, it doesn't say that they can't ask for it. Usually, the way that I understand insurance, if we can't get something one way, we'll do underwriting a different way. But it doesn't say that you can't ask for it.
The bill does not, correct.
Okay. And regarding express consent, that is not like doing, thinking of a EULA, right? Where end user license agreement, when you fill out whatever doc and you're downloading, is express content considered that 50-page document that says we're going to use your data for whatever we want to use it for?
So sorry.
Or is it they say, well, this place wants the data, do we have to get your express consent at that time?
So I don't think the bill is clear on that. It's a good point. You see some data privacy bills that are very detailed in how the consent must be provided or received. In this case, we have a definition. It's clear, meaningful, prominent, right? Does that mean it can be 150-page? To me, I think, yeah, that's actually would be allowed. Because if I'm a direct-to-consumer genetic testing company and this bill passes and I look at this and I see that we need our customers to consent to all these things, you're going to have 10 checkboxes, one after the other, next. I mean, you could do that, or you could have just one giant agreement that you check at the end. Is that express consent? In my opinion, maybe people will differ on this. I think the bill is not clear on it. That would be okay. So I think if you want to be more consumer friendly, you can make this more clear on how you want the consent to be gained. If you want to be more friendly to the companies who shouldn't make 10 or 20 checkboxes, then you can either leave it as is, in my opinion, or you can be more lenient on express consent, how that works. Does that make sense?
Yeah. I don't want to take away somebody's rights to, or a company's right to do the 50-page thing, but then again, I also want to take away their rights to do that so that I know what I'm signing off. None of us read those. Yes.
Unless if they have like a bullet pointed summary or something
Yeah.
at least that brings the information up to the top.
Yeah.
Because, yeah, we're not gonna read 50 pages.
I think Rick is the only one that's read that.
Oh, yeah, read all those, yeah. I read all those.
Um. Oh, that's a really good idea.
Or fine print
To
readers.
see the look on his face.
I just wanted to jump back to the whole issue about whether this is like strictly DNA or health. I just pulled up 23andMe's website. And they do seem to test for health, or they at least are making health inferences with the data that they're getting. And I think that's part of the business model for a lot of these genetic testing sites, or they want people to be able to go to them to continue for their health analysis. So it might be something that we have to put extra scrutiny on.
And from the insurance. Jumping in, from the insurance side, the thing that we have to weigh is, this data point that we have will help lower cost of premiums. Because insurance companies can make quicker decisions and sometimes better decisions.
From a consumer protection and privacy issue, it like.
Correct. But you don't have to get life insurance. You should.
Of course, yeah, but when it comes to issues like actual health insurance, I know that's that is,
So,
yeah. I mean, I know that's not necessarily what our committee deals with directly, but I do think from a consumer protection kind of standpoint, it's something that we should think about. Just because it complicates, your point, it complicates the waters.
So, trying to get my head wrapped around this and how it relates to other statutes. And there are some, might not be the same thing, but there are some insurance statutes that we talk about genetic testing. And I always remember them to be fairly restricted on the insurance company in terms of what they offer, don't offer, cover, stuff. Maybe I recall that differently. I'm just trying to understand whether this is maybe inadvertently expanding on what an insurance company can do in connection with genetic testing.
Well, so Ripple, what I would say is this bill is specific to these genetic testing companies, right? We're not regulating health insurance companies. Well, we're saying that these companies cannot sell to health insurance providers or life insurance providers,
Right.
right?
Right.
So that's why I can't, because I think my colleague Maria would be able to, or maybe Jen Carby would be able to come and talk about, here's what we currently have on health insurance companies related to genetic data. I don't know. I think you're right. There are,
or life insurance companies.
or right, life insurance companies. So there are,
And I'm just wondering if a life insurance company, or I guess any other insurance company, could acquire the information from one of these service providers.
I see what you mean.
That you might be inconsistent with the underlying.
How would they acquire it?
Yeah.
How would they acquire it if it's,
From
if this bill passes and becomes law, how would the life insurance company
Well,
acquire
that's
it?
a good question. I suppose it would have to be with consent.
Of the consumer?
Yeah, so you got the insurance company would maybe want to acquire the testing data from this type of company. And I'm just trying to, maybe it's not relevant. But yeah, that would be good, maybe to check with Maria about, how that,
Yeah.
the anti-discrimination statutes in insurance law relate to this, or not, I suppose, maybe they don't.
Yeah. Just thinking, I don't know of any insurance companies that actually use this kind of data. But it's not like I've been to too many insurance companies.
Maybe it's because might be because of the underlying statute.
Right, which makes sense, right? Like, I mean, I'm just thinking of the data points that could be collected, and some of those data points could get you into some really sketchy areas of danger. Yeah, but regarding the express consent, I think that, the whole upfront 1,000-page approval, I think that would probably cover express consent, and then folks can just sell this information, but I think it would.
Well, not sell, but using it in certain ways, storing it in certain ways, but not necessarily selling the genetic data.
So if you have a contract with a company that can ping the database, would that be considered selling?
Ping which database?
Well, the database of the genetic information.
Tell me, sorry, I don't follow what the transaction is.
So if you have a contract with a company, it's similar to data brokers.
Mhm.
If you have a contract that allows you to search their database for information, is that considered selling?
So let me show you subdivision D. So express consent for each transfer or disclosure of the consumer genetic data or sample to a third party other than this service provider that carries out their business.
So it would require every single transaction to get express authorization.
Yeah, and then we define disclose pretty broadly up here. There it is. Solicit, sell, assign, transfer, give, provide, trade. So yeah, I think you're right.
I think it would be interesting to see what the insurers say on that. My guess is they probably don't use this data.
I don't think so. It's more in the. You're specifically going to your doctor's office and asking for a test. And not disclosing the results of that test if you purchase a life insurance. I think that's what the issue was with the UVM, is that it would have prohibited the insurers from getting that information.
But when you get life insurance, you sign off on getting medical records. So
Yeah, but it would have prohibited insurance companies from being able to get that record.
And at the time, if I remember, the insurer said they didn't use these kind of direct consumer things because it wasn't actually precise enough the way.
And there is a non-disclosure coming up, so let's hold if we can. There is language specific to that they cannot disclose to entities that are responsible for health insurance decisions, life insurance decisions. So maybe let's hold off on that until we see that language, because that might affect how you think about it. Okay, shall I continue? All right, so subsection B, we have a marketing exception. So I'm going to leave E on the screen because it references E. So subdivision A2E, right above, does not require a direct-to-consumer genetic testing company to obtain a consumer's express consent to market to the consumer on the company's own website or mobile application based upon the consumer having ordered, purchased, received, or used a genetic testing product or service from that company if the content of the advertisement does not depend upon any information specific to that consumer. Cookies, I think, is what we're talking about here. Right? Nothing in the subdivision alters, limits, or negates the requirements of any other anti-discrimination law or targeted advertising law. So number two, any advertisement or of a third-party product or service presented to a consumer pursuant to that exception shall be prominently labeled as advertising content and be accompanied by the name of any third party that has contributed to the placement of the advertising. If applicable, the advertisement shall also clearly indicate that the advertised product or service and any associated claims have not been vetted or endorsed by the direct-to-consumer genetic testing company. Okay, C, revoking consent. So really a direct-to-consumer genetic testing company that has requested consent, express consent from a consumer shall provide effective mechanisms without any unnecessary steps for a consumer to revoke consent after it is given, at least one of which utilizes the primary medium through which the company communicates with consumers. If a consumer revokes consent, the direct-to-consumer company shall honor that revocation as soon as practicable, but not later than 30 days after the individual revokes consent. And if the revocation is related to the storage or use of a consumer's biological sample, destroy that sample not later than 30 days after receipt of the revocation to consent.
You're making notes to yourself.
Yep.
Without any unnecessary steps, can we just have that be at least as simple as?
Let's see.
It was in one, under revoking consent, one, direct consumer genetic testing.
Without any unnecessary steps, what would you like?
At least as simple as, at least as, whatever, as signing up for the cert, something, I mean, unnecessary is such a unclear.
Eye of the beholder.
Yes,
Okay, shall provide corrective mechanisms. And your suggestion for granting is something like,
at least as simple as, at least as, there, there's a language
yeah.
that we have used for other things.
Okay.
Don't want to miss that as we go back.
Got it?
I'm sorry, I have to go back because I'm a little confused and I just want to make sure that I fully understand. So if a doctor orders a genetic test, this is going to apply. No, okay. Okay, I got a little confused as we were talking because I'm thinking of medical records and, the medical records on the left side, it says
Right.
all the different, health issues. And I just checked to make sure, like. Okay.
Yeah, good. Yeah.
Never mind.
Subsection D, line 4 on page 11, data security and access. A direct-to-consumer genetic testing company shall implement and maintain reasonable security procedures and practices to protect a consumer's genetic data against unauthorized access, destruction, use, modification, or disclosure, and develop procedures and practices to enable a consumer to easily access the consumer's genetic data, delete their account and genetic data, except if it's required to be kept by law, and request to have the consumer's biological sample destroyed. Subdivision 2. Genetic data and biometric samples of consumers shall not be stored within the territorial boundaries of any country currently sanctioned in any way by the U.S. Office of Foreign Assets Control or designated by as a foreign adversary under 15 CFR 7.4a. Those are, China, Iran, Cuba, some examples, North Korea. 3, genetic data or biometric data of consumers shall only be transferred or stored outside the U.S. with the express consent. So notice number 2, you can't do it all, right? You cannot store it in these certain countries. Number 3, only outside the U.S. upon express consent of the consumer. But yes, China is listed as one of these countries. I don't know how common it is for companies to use China as storage. I don't know, but something to think about. Subsection E, contracts. A contract between a direct consumer genetic testing company and a service provider shall prohibit the service provider from retaining, using, or disclosing the biological sample, genetic data, or any information regarding the consumer, the identity of the consumer, including whether that consumer has solicited or received genetic testing for a commercial purpose other than providing the services specified in the contract with the business. Associating or combining the sample, genetic data, or any information regarding the identity of the consumer, including whether that consumer has solicited or received genetic testing, with information the service provider has received from or on behalf of another person or persons, or has collected from its own interaction with consumers or as required by law. Subsection F, discrimination. A person or public entity, this will appear in a second why that's there, shall not discriminate against a consumer because the consumer exercised any of the consumer's rights under the subchapter by denying goods, services, or benefits to the consumer, charging different prices or rates for goods or services, including through the use of discounts or other incentives, or imposing penalties, providing a different level of quality of goods, services, or benefits to the consumer, suggesting the consumer will receive a different price or rate for the goods, services, or benefits, or a different level or quality of goods, services, or benefits. And 5, this is the public entity, considering the consumer's exercise of rights under the subchapter as a basis for suspicion of criminal wrongdoing or unlawful conduct. Okay, G is the, sorry.
No, I'm sorry.
Okay. A subsection G is the subsection I was referring to earlier, non-disclosure. So notwithstanding any other provision in this section, a direct-to-consumer genetic testing company shall not disclose a consumer's genetic data to any entity that is responsible for administering or making decisions regarding health insurance, life insurance, long-term care insurance, disability insurance, or employment, or to any entity that provides advice to an entity that is responsible for performing those functions. So I think that clears up some of the. Yeah, maybe not everything, because they can get, but how would they get it, right? That's my, yeah. Okay. Enforcement is going to be your standard Vermont Consumer Protection Act language. So a direct-to-consumer genetic testing company or service provider that violates a subchapter or rules adopted commits an unfair and deceptive act, bringing it into play the Vermont Consumer Protection Act 2453 of the title. The AG shall have the same authority to make rules, conduct civil investigations, bring civil actions. Again, this is your standard language under the Vermont Consumer Protection Act. Okay, applicability. The provisions of the subchapter shall not reduce a direct-to-consumer genetic testing company's duties, obligations, requirements, or standards under any applicable state and federal law for the protection of privacy and security. In the event there's a conflict between this law and any other law, the provisions of law that afford the greatest protection for the right of privacy for consumers shall control. Subsection C. I'm going to not read these word for word because these are your typical HIPAA, other federal research exemptions from the law. So 1 is HIPAA. 2 is a different type of protection under HIPAA. 3, HIPAA. 4, scientific research or educational activities conducted by a public or private nonprofit, post-secondary. So this is your research done at the collegiate university level, government research. Okay, 5, tests conducted exclusively to diagnose whether an individual has a specific disease, to the extent that all persons involved in the conduct of the test maintain, use, and disclose genetic information in the same manner as medical information or protected health information as described in the HIPAA protection of this section. Genetic data used or maintained by an employer or disclosed by an employee to an employer to the extent that the use, maintenance, or disclosure of that data is necessary to comply with a local, state, or federal workplace health and safety ordinance, law, or regulation. And D, nothing in the subchapter shall be construed to affect access to publicly available information. So remember the definition earlier, if there's information that has been gained through government records or through widely distributed media, this bill does not affect those disclosures. And then the effective date is July 1, 2026.
Stupid question. Why would an employer need genetic data?
I imagine some employers do testing. Remember, genetic data is very broad, right? I'm not an employer, so I don't know what the purpose would be. But if there's a local, state, or federal law that requires the employer to have these results or do these testing, then it's very narrowly drawn to where just that one, if you're required to comply with a law and you must do this testing, then that is permitted in this bill.
Sorry. So as we were reading, we saw the medical tests that were done by doctors. So, and I'm probably just thinking too much about it, but I've had, 23andMe done. I bring it to my doctor. My doctor reviews that and says, oh, that's a problem. They note it in the medical records. That's part of the medical records that it doesn't get redacted as they were sent out, correct?
Sent out where?
To an insurance company. That gets back to the anti-selection that you were talking about, and that's what I'm concerned about. Because somebody has Huntington's disease, their genetic data. They go to the doctor,
Right.
They show the DNA, the doctor says, oh, hey, we should probably get the official test for this.
Right.
And the person says, you know what, just hold off just 1 minute. I'm gonna go get insurance. This happens. This does happen. That information, is it redacted from, does this require a redaction?
That's a good question.
I would have a huge problem if it does.
Because there's no requirements on medical providers in this bill. It's just the genetic companies, testing companies. So I would say no, but I don't know if there's other laws on the books that either federally or statewide that already protect that information, because I would imagine
Possible. I'm not worried about.
it may be happening, but it may not be,
Right.
legal.
Well,
I'm just, as we talked about this.
You're want to purchase life insurance. You have to give your consent to allow the insurance company to look at your medical records. Right?
But when we were talking about the UVM issue, didn't you say that it was not part of the medical records? Or,
Well, that didn't go through. Yeah.
right, okay.
Number 5, right there. It's not what covered.
That's if the doctor does it. We're talking about if I do a 23andMe, I go to my doctor and
Maybe-
show
Yeah,
them.
but you're disclosing that as a consumer, you're disclosing that to your doctor.
Okay. Yeah, as long as,
I don't see how, and then you're giving the insurance company the right to check your
okay,
medical record, right? So if it becomes part of your medical record, it's all a choice that you as a consumer made, right?
and that's fine. As long as the medical records aren't redacted, that's what I was concerned about.
Is this based off another state's?
But it's So I mentioned before, several states have this. They come in different forms. California's was inspired, or California's inspired this draft. It's not word for word, but California's is more recently updated. So the thought was to have Vermont's be, since we're a little bit later than other states, to be kind of more learning from the mistakes of other states. Yep.
Any questions?
I would just think, Mike, that a lot of the issues you're talking about, I think are a matter of HIPAA law.
Yeah.
And that regulates the medical records and who gets to see them and what exclusions are. So I kind of think I can understand the construct of how this bill was put together. It said, okay, this doesn't apply to these records because HIPAA does. And I don't know all the details of it, but it's pretty common.
Yeah, I think I get confused very easily, so it's always better not to give me any information. But I just wanted to make sure that I understood it the way that I think I don't think I have a problem. That's all. Not that, you know, everything relies on whether or not I have a problem with it.
Any other questions? Okay, good, thank you.
Hey, you're welcome.
We have invited Representative Shire to come in tomorrow. Kind of give us the reason and her reason. Right. Any questions? So tomorrow morning, we are, instead of taking up H to 11 because of it witnesses in, we'll be going through all the new bills that came in. We'll be hearing from their sponsors tomorrow. And then in the afternoon, we'll be hearing from the Human Rights Commission. Be at 1:15, then at 2:15, we'll be hearing from the Vermont Captive Insurance Association. Then we have, yeah. So that's it. Any questions on